D. Legislative inquiries and oversight functions. Requisites of legislative inquiries. Must be in aid of legislation. B. Is in accordance with duly published rules of procedure. C. Right of persons appearing in or affected by such inquiries shall be respected. Bengtson v. Senate Blue Ribbon Committee, GR number 89914, 1991. Legislative inquiries versus question hour. Legislative inquiries apply to matters in aid of legislation, while question hour to any matter pertaining to the subject's department. Legislative inquiries apply to any person upon subpoena, while question hour to heads of departments only. Legislative inquiries apply to appearance of executive officials and is generally mandatory, while question hour to appearance of executive officials via request, and upon executive officials' volition with President's consent. The mere filing of a criminal or an administrative complaint before a court or quasi-judicial body should not automatically bar the conduct of a legislative inquiry. The requirement of securing prior consent of the President prior to appearing before either House of Congress applies only to cabinet members and not to other public officials, and only when either House of Congress conducts a question hour, and not in cases of inquiries in aid of legislation, as the latter should be untrammeled because it is coextensive with the power to legislate. However, in Gudani v. Senga, the court clarified the above authority over the military. It held that obedience and deference to the military chain of command and the President as Commander-in-Chief are the cornerstones of a professional military in the firm cusp of civilian control. In the same case, the Supreme Court also ruled that any chamber of Congress which seeks the appearance before it of a military officer against the consent of the President has adequate remedies under the law to compel such attendance. Final judicial orders have the force of the law of the land which the President has the duty to faithfully execute. If the courts so rule, the duty falls on the shoulder of the President as Commander-in-Chief to authorize the appearance of military officials before Congress. Executive privilege. Executive privilege is the right of the President and high-level officials authorized by him, her to withhold information from Congress, from the courts, and ultimately from the public. Among the types of information which have been judicially recognized as privileged are state secrets regarding military, diplomatic, and other national security matters. Certain information in the possession of the executive may validly be claimed as privileged even against Congress, such as presidential conversations, correspondences, or discussions during closed-door cabinet meetings. Who may invoke? Only the President can invoke it. She may also authorize the executive secretary to invoke the privilege on her behalf, in which case, the executive secretary must state that the act is by order of the President, which means that he personally consulted with the President on such matters of concern. If the President and Congress cannot agree on whether the matter is privileged or not, then the court must come in to determine the validity of the claim of privilege. Contempt power. As long as there is legitimate inquiry, then the inherent power of contempt by the Senate may be properly exercised. Conversely, once the legislative inquiry concludes, the exercise of the inherent power of contempt ceases, and there is no more genuine necessity to penalize the detained witness. As the Senate is not a continuing body, all inquiries automatically end once the Senate adjourns sine die, i.e., at the end of the third session of each Congress. The imprisonment for contempt automatically terminates on such date as well. Contempt of congressional oversight. Broadly defined, the power of oversight embraces all activities undertaken by Congress to enhance its understanding of and influence over the implementation of legislation it has enacted. Clearly, oversight concerns post-enactment measures undertaken by Congress. 1. To monitor bureaucratic compliance with program objectives. 2. To determine whether agencies are properly administered. 3. To eliminate executive waste and dishonesty. 4. To prevent executive usurpation of legislative authority. And 5. To assess executive conformity with the congressional perception of public interest. Categories of congressional oversight functions. The acts done by Congress purportedly in the exercise of its oversight powers may be divided into 3 categories, namely, scrutiny, investigation, and supervision. Scrutiny. Passive inquiry. the primary purpose of which is to determine economy and efficiency of the operation of government activities. In the exercise of legislative scrutiny, Congress may request information and report from the other branches of government. It can give recommendations or pass resolutions for consideration of the agency involved. Legislative scrutiny is based primarily on the power of appropriation of Congress. Under the Constitution, the power of the purse belongs to Congress. Legislative scrutiny does not end in budget hearings. Congress can ask the heads of departments to appear before and be heard by either House of Congress on any matter pertaining to their departments, pursuant to Section 22, Article 6 of the 1987 Constitution. B. Congressional investigation. More intense digging of facts compared to scrutiny. Power of investigation is recognized by Section 21, Article 6, 1987 Constitution. Section 21. The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. C. Supervision. Note: this is unconstitutional. Connotes a continuing and informed awareness on the part of a congressional committee regarding executive operations in a given administrative area. Allows Congress to scrutinize the exercise of delegated lawmaking authority, and permits Congress to retain part of that delegated authority. Through this, Congress exercises supervision over the executive agencies. Note: legislative supervision is not allowed under the Constitution because of the doctrine of separation of powers.